I'd like to join the judge and welcome you down here at County Court of Law number 2. My name is Kenneth Oden. I'm the prosecutor in this case. I was sent down here to try this case by your elected county attorney, Miss Margaret Moore. This will take probably a couple of days of your attention, and I hope your close attention. It's very important that you've come down here and seen fit to take time out. It's very important to us. It's very important to my office, to the people of this community that I represent. I'm sure it's also very important to the defendant in this case, Mr. Victor Alvarez, as well as his attorney. We thank you for coming down, and we hope that you can give us your complete and undivided attention. This is what is known as the voir dire segment of a criminal trial. This will be a criminal case. If you sit on this panel, ultimately, as a juror, you will be asked to answer questions that are relevant to every criminal case. It's a unique portion of a criminal proceeding in that it's the only time that we will actually be able to speak with one another on a one-to-one basis. It's the only time that if something's going on, something clicks in your mind and you say, well, I'm not sure about that, or I'd like to know more about that, you can actually raise your hand, and I encourage you to do so. We can talk about it. It's a very important stage in the proceedings. I know we're all strangers here. It's kind of a strange setting for you, and I can assure you I'm probably as nervous as you are. I haven't done very many of these. Mr. Autry, on the other hand, is a very experienced and eloquent speaker. He's been through this many times, but one thing I at least have in common with you is it's pretty new to me, and I'm kind of nervous about the process. But I assure you that it's important enough, and we all have the best intentions here, and it's important enough that we that I and that you as well overcome some of your timidity and go ahead and talk with me. So when something comes up in your mind and you want to ask me about it, you just want to talk about it, don't be bashful. Raise your hand and see if I can't clear it up, or I'm not sure I'll be able to, but it's very important that we be able to talk frankly with each other. The purpose of this segment of voir dire is to try to come up with a set of jury members, 6 of you, that can sit as fair and impartial jurors in this case. That sounds pretty simple, and I'm sure everyone's here, if you've met the minimum qualifications to even be considered to be brought down here, I'm sure you're all good people. However, in every one of our backgrounds, there may be things that force us, or something that we're not even aware of until we stop and think about it, that might give us a little different slant on an issue or some type of criminal proceeding or anything that may come up in this trial. And as we talk about it and learn a little more about it, then you may see things that you may even yourself were unaware of that may make you start out with a bias one way or another, or you may just have some convictions about this case as I introduce it to you that we need to at least talk about. In the course of this part of the proceeding, it may be necessary from time to time for you to come up, especially if it's something that's personal to you. Don't be ashamed to say, I want to talk to you about that. We can come down and come up in front of the judge. It's just as normal as it can be. It happens every day. It's what this type of proceeding is supposed to be all about. And if something like that comes up, we can always go before the judge and talk about it a little more privately, and I assure you that's going to happen sometime in this proceeding. Don't be ashamed if it happens to you first. We just need to talk very frankly with each other. The witnesses that I expect to call in this case, there are 3. Most of our witnesses will be police officers of one sort or another. We have 3 officers, Officer Carlton Jones, Officer Cannon, and Officer Malcolm Robertson, who are all police officers with the University of Texas Police Department. Is there anyone here on the panel who knows any of these officers personally? Any of their families or any acquaintances? I should ask you also, is there anyone on the panel who knows me or Mr. Autry or the defendant, Mr. Alvarez? Think about your silence. You do not. I expect also to call at least one, probably two police officers from the Austin Police Department. There will be an officer who is a chemist and a toxicologist named Mr. Rudy Baker. Is anyone here who knows Mr. Baker? Is there anyone here, another officer named Malcolm Mills, I expect will probably be called. Does anyone know Mr. Mills? I should, if you hadn't noticed, that will probably be all our witnesses, and they all form in one fashion or another in law enforcement, whether as a UT police officer or an Austin police officer or a chemist for the police department. They all work for the police department. Ms. Ford, do you think there's anything about that, about the fact that all our witnesses will be police officers, that make you feel like there's anything wrong with that, if all the witnesses on one side will be police officers?
No, that seems logical.
It's my intention in this case to bring you all the evidence that I can, all the evidence that is legally admissible at this stage of the proceeding. It just so happens in this case that the evidence that I'm able to bring forward to you, all the forms combined will be adduced by police officers. Is there anything in any of your backgrounds? You know, I'm sure we've all had a traffic ticket from time to time, and some things that you may have come at odds with a particular policeman or someone in law enforcement that might have left a bad taste in your mouth for at least a short period of time. I hope not too long. But is there anyone that feels like they have had any dealings with Austin Police Department or the University of Texas Police Department or law enforcement in general that might make you feel a little biased, say, against police officers?
I've had a traffic ticket, but I was speeding and the officer gave me a ticket. I don't think I've ever had a bias.
Okay, did you go to court on that, Mr. Person?
No, it was just a matter of me paying a fine.
Is there anything in your experience with through that process that kind of left a bad taste in your mouth? You might have any vindictiveness?
No, I was speeding, and I sure couldn't argue with that, and the officer was pretty polite with me.
What do you think about that, Mr. Bird?
Well, I was arrested once, but it was for DWI. And I know the officer was doing his job and everything, and I was released because I only...
Well, let me excuse me for interrupting. We might want to go up in front of the judge and talk about this. Just say, do you mind?
No, not at all.
Assume that you are before the judge.
At this point, I would ask to do this ordinarily out of hearing the other jurors. You say you were arrested in a prior DWI.
Right.
Did that case ever go to trial?
No, I was released the same night. So.
But you were released the same night?
No, because...
Was the case ever disposed of?
Well, it never really began. I was, arrested and released the same day.
Okay. How long ago was it?
That was about a year ago.
Okay. Do you have any knowledge as to whether or not the case might still be pending against you?
No, I don't think so.
Do you remember ever paying a fine or doing anything related other than the first night that you left there?
No, that was about it. It was cleared up the first night.
At this point, I would challenge you to pause.
Well, may I ask?
Yes, you may.
As a result of your release, you had the charges dropped from you that evening, is that correct?
Yes.
And is this the result of a scientific test that was administered to you?
Yes, breathalyzer.
And the results of that breath test then resulted in a reading so low there was no presumption of intoxication and they dismissed the charge.
Correct.
Well, I'd like to ask, what is your view on the breathalyzer as a method of testing one's state of sobriety? Since it was in your favor on this occasion, I guess you found it easy to believe.
Well, that depends. I know I didn't have that much to drink that night, so.
And the breathalyzer machine vindicated that belief.
Right.
But now, had it been on the contrary, and a reading of, let's say, 0.15 or thereabouts, would you have today the same degree of faith in its veracity?
I would object to that question, Your Honor, and that it's probably for a conclusion on the part of this veneerman that he's not capable of making. He probably doesn't know the difference in 0.15 and 0.05.
Well, Your Honor, we are examining this witness before the court, and not in front of other jurors, and I wanted to inquire to see if he would be influenced as a result of possible scientific evidence to be introduced in this comment.
Mr. Oden, was the question if it had that amount to drink and the breathalyzer had shown a reading of 0.15, would he still have faith in it? Was that your question?
No. My question was directed, and maybe poorly so, but it was to determine if he had consumed a quantity of alcohol sufficient to justify a reading of higher than what was the case. Well, would he still have the faith in the accuracy of the machine that he now does?
Ask him again. I don't think I understand the question. Ask him and see whether he does.
All right. Well, let's suppose you had consumed the greatest quantity of alcohol. Well, really what I'm interested in, did the experience with the officers testing you cause you to place a great deal of faith in the accuracy of the machine, the breathalyzer machine?
Well, judging from that one experience I had, it proved to be correct, so, because I didn't have that much to drink.
Then if you were to hear evidence that the machine with another individual registered a reading of 0.14 or 0.15, would you tend to believe that?
I guess I would want to know from him how much he had to drink before that.
And I think the defense is
I think we're both a little scared of this guy, but I want to ask more questions and we can go on forward, or we can.
We're eating into Mr. Oden's time. Being the sort of judge I am, I will overrule both challenges for cause.
As I said before, this is a criminal trial, and the charge against Mr. Alvarez is that he was driving while intoxicated, that he was basically caught driving on a public road in Travis County, Texas, while under the influence of intoxicating liquor. What we believe the evidence will prove is that several UT police officers observed Mr. Alvarez after having him brought to their attention by some erratic driving and a couple of minor traffic violations that brought him to their attention, and for the purpose of stopping and investigating the erratic driving and for the purpose of basically making a traffic stop. They spoke with Mr. Alvarez, they observed him, they observed his demeanor, and in their trained opinion, they believed that Mr. Alvarez was intoxicated, too intoxicated to be on the streets of this community driving an automobile. In a nutshell, after making that determination, after giving Mr. Alvarez what are called certain sobriety tests on the scene after they pulled him over on the traffic stop to determine whether or not he was intoxicated, they felt the sobriety test indicated he wasn't too intoxicated to be driving. At that point, he was placed under arrest, brought down to the Austin Police Department, where he agreed to take a chemical breath test. Throughout the trial, there will be a lot of evidence adduced on the use of a breathalyzer instrument and the reliability of breath tests. Actually the law is pretty clear on that, but We think the evidence will show that Mr. Alvarez chose voluntarily to take this breath test, and that he then showed on the instrument a percent of blood alcohol that was so great, the officers had no choice but to charge him then with driving while intoxicated, and that's why we're here today. I will get to a little bit later some of the law that does apply in a case like this, where someone is charged, as Mr. Alvarez is, with driving while intoxicated and has taken a chemical breath test. There will be several different forms of evidence, and a very persuasive, one of the, I feel, extremely persuasive, and the people who make the laws in this state obviously feel it's very persuasive too, and that is a chemical breath test. Is there anyone who's never heard of the breathalyzer or chemical breath test? Does everyone understand the basic rationale behind that instrument to test how much alcohol you have put in your body? Is there anyone, Mr. Daly? I'll
Yes,
kick you out and ask you a couple questions about that. You've heard of the breathalyzer instrument before?
yes, sir, I have.
Do you know very much about it?
Oh, just a little bit, just about what you've told us already, sir.
Okay. Is there anything that you know about the machine that you feel like it's unfair to use that machine, or is anything unreliable about the machine you thought?
No, sir, not as far as I know. It always sounded like a good idea to me.
Some of the, as this trial proceeds, what I like now to do is talk about some of the very basic legal principles that we would have to deal with. I hope, don't hold it against me if I talk down to you a little bit here. I think most of these points that I'm going to raise, we've all heard of them. We all hear them kicked around ever since you've probably been in the 6th grade civics class. Most of these concepts are back there. But I think it's important that we kind of refresh ourselves and kind of orient ourselves where we are and what will be expected of you, and give you a little chance to kind of think about it. You may have some questions of me as we go along. There are certain legal principles that incident to every criminal trial has in common. Every defendant has a right to a trial in this country, a trial by a jury of his peers. That's why you have been brought down here today. Your job will be to judge, and you are the sole judge of the facts in this case. I will be presenting evidence to you from the witness stand, trying to draw out evidence that I believe proves this case. The defendant will be trying to do otherwise, and the judge will give you the law that you are to apply as we go along. You have one primary and very important role in this proceeding, and that is to determine the facts. You start out with something called the presumption of innocence. I'm sure we've all heard of that, and it's a very important part of our process, and one I have absolutely no quarrel with. We are to presume at this point that Mr. Alvarez is innocent. That presumption only obtains until I bring you credible evidence to remove any reasonable doubt that you may have as to whether or not he really is innocent. I intend to do that. I will remove any reasonable doubt that you have, because I have that kind of evidence. The burden of proof.
That'd be sustained, John.
The burden of proof in this case rests upon the state. What I mean to say is that we have to come forward. We can bring a citizen in here and charge him with a crime, and then we have to come forward and prove it. We intend to do that, and the burden that we have in proving this case is to remove any reasonable doubt that you may have to the elements of this crime. Now, that's very important. What I'm talking about there is that, you know, when I've got 5, 6, 7 officers that are going to come in here, I don't know how many witnesses the defendant may have, I don't know the defendant, who he will choose to bring forward in his behalf. But that's quite a few people. I'll be asking questions, he'll be asking questions. This could take a day or 2, maybe even 3 days. And in that process, you're going to hear some conflict. But the basic elements of this case are what you have to concern yourself with. Was he driving on a public road in Travis County, Texas, while he was so intoxicated that he lost the normal use of either his physical or his mental faculties? Those 2, 3, 4 things. And you know, I don't expect this is going to be the type of proceeding that we're going to be really out there arguing about, was he driving an automobile? Was he on a public road? Most of us probably know the street that he was driving on, probably been on it ourselves. I don't think there'll be a big quarrel. Was it in Travis County? You know what he's going to be trying to convince you is he wasn't drunk. He wasn't intoxicated under the legal definition that is imposed in a case such as this. That's what it's going to get down to. Was he driving a car and was he intoxicated? And that is what I have the burden of proving.
You have 10 minutes, Mr. Russell.
And when we get down to worrying about was he wearing a red shirt or some things that do not really bear on the elements of this case, then we're getting to points where I do not have to bear the burden of proof. If I prove those things to you, that he was driving an automobile in Travis County, Texas, and he's intoxicated, is there anyone that's going to worry about these ancillary periphery matters? Another important part of the system, of the Texas system of criminal justice, is what is called a bifurcated trial. That's a big word. It means we have a 2-stage trial, a 2-step process. The first step is where you come in, and it's where we decide what are the facts. Did he do it or didn't he? Is he guilty or is he not? And it's very important that you keep in your mind that that is your purpose and your only purpose. It's very important. But in a 2-step process, the second stage only comes into play once you've answered that first step in the process. Did he commit this crime or did he not? That's so important because you really have a different mindset completely of how to approach the evidence that I bring forward if you understand what your purpose is here. Because the second step of this proceeding is only to determine what do we do now that we have determined he is guilty, if you determine he's guilty. It's not even the same set of evidence. I'll bring you, I think, evidence that will show his guilt beyond a reasonable doubt. And I will bring you all the evidence that I am permitted to do on those issues, on those elements that settle that issue. But in the second stage, it's very important that you understand that it's only to the second stage that we get to questions like, how should we deal with him if he is guilty? Does he deserve a second chance? Does he deserve some amount of sympathy? You know, I'll tell you that in this first stage, sympathy has no place in this trial. That sounds like a harsh statement. I'm not saying sympathy has no place in the criminal justice system, but in this first step of the proceeding, I'm going to ask you, can you stick to the law? Can you, I'm not saying be dispassionate, but save your sympathy for the second stage so that if you determine he is guilty, that you or the judge will then decide, does he deserve sympathy? You know, at that second stage, there's a lot more credible evidence. You can say, what will we do with it? We can bring on evidence of his reputation in his community. Does any particular defendant, what is his reputation? Does the defendant have a prior criminal history? Things like that. That comes along in the second stage. But that doesn't come along in the first stage, and for that very good reason that we have that limited purpose of just determining is he guilty or not. I think in this case, actually, the defendant has opted and filed papers in this case necessary to make sure that if he is found guilty, the judge will in fact assess the punishment. And that's why it's so important to me that as laudable a feeling as it may be to have sympathy for someone, that I extract a promise from you that you can save your sympathy for that second stage of the process. Does anyone have any quarrel with that?
But that means that we don't get to use any of our sympathy to sympathize with the fellow if it's going to be that judge or some other judge deciding.
Yes, sir, because if the trial ends at this stage, that would be true because of the limited purpose for which this first step of the proceeding is meant to accomplish. This first step is saying we'll just determine that one issue, did he do it or not? And then we'll invoke our sympathy if any is deserved.
So if we think he deserves a second chance, we're not going to get to give that chance.
Well, I'm not sure. He has filed papers necessary in this case to make sure that decision be made by someone other than you. Mr. Alvarez has opted to have the judge assess punishment, and he will make those arguments for or against any sympathy to the judge. He has that option, and that's what he has decided to do. Probably the trickiest thing, I think, is something really important in a crime that relates to intoxication. Excuse me, how much longer? 5 minutes. Okay. I assume, is there anyone here who doesn't drink at all? Okay. Mr. Burleson, do you have any feelings, religious or personal convictions that you feel like related to drinking that would make you unable to sit as a juror in this case and unable to be fair and impartial about it?
Well, I personally don't drink for religious reasons, but they are personal, and members of my family drink. I've got friends that drink. I don't try to force my beliefs on other people, and I think I could sit and determine fairly whether or not the gentleman was drunk or not drunk at the time that the officers arrested him.
I understand. That's very reasonable. How about you, Mr. Blake?
Well, I don't drink for religious reasons, moral reasons. I'm withdrawing from it.
Let me ask all of you this question. Is there anyone here who's never seen someone they thought was drunk? We probably all at one time or another seen someone that said, well, they're pretty loaded. What I'm going to propose to you is, when we talk, we use little things, we say, well, he's drunk or he's not drunk, and a lot of times what we mean, just in common everyday practices, this guy is really in a mess. He's falling down drunk. When you say he's drunk, you mean he just lost so much, it's so obvious to anybody that deals with him, maybe he's just falling down drunk. Well, the laws of the state of Texas say, basically, I think you will be given a law that will make it obvious to you that a long time before you get falling down drunk, you're too drunk to be behind the wheel of an automobile. That's what the law of the state says. A person is deemed to be intoxicated or under the influence of intoxicating liquor when within the meaning of the law, or within the meaning of the law, when he does not have the normal use of his physical or mental faculties by reason of the use of intoxicating liquor. And it's important that we say, I'm going to give up something here. I'm going to give up my preconceptions of what I think how bad you got to be before you're too drunk to drive, and I'm going to follow the legal definition because I'm taking an oath to follow the law in this case as a juror. Is there anyone who believes they could not do that? Is there anyone who believes that they couldn't follow the law that's given to you from the judge and use that legal definition? That's very important. I hope y'all can do that. I'm sure you can. I'm going to ask you a few individual questions, and I'm going to encourage you. If something comes along and you say, well, I'm not sure about that, ask me the question. Mr. Burleson, I noticed here you're a student. Where do you go to school?
University of Texas.
In your stay over there at the university. I went to university, undergrad school. Have you seen anything about the University of Texas Police Department that made you feel like that they just can't be trusted?
No, I've never really had any dealings with them. I see them on the campus, that's about it.
I know you've been here a short period of time, about 6 months. Where did you live before that?
Well, I've lived here in Austin for most of my life.
I see. Mr. Bird, what kind of business are you in?
Well, I work for a corporation, and Pontiac, Michigan. That's my place of birth. Here in Austin. Sorry about that.
Let me ask you something, Mr. Daly. It's a little bit personal, kind of relates to your job. I see one of the things that you have some training in is as a medical aid.
Well, really not much training. I just do mostly odd jobs around Travis State School.
You had any of your training or anything worked around hospitals or had anything to do with victims of accidents, car accidents, or anything like that?
Oh, no, sir. At the state school, we don't see that kind of thing, so I haven't done that kind of work.
Have you had the occasion to observe, do y'all treat people who have alcohol-related problems out there?
Oh, I think occasionally, maybe so, but I haven't worked with that kind of
I see.
case.
Just a few more seconds, Shirley.
Okay. I notice you, Mr. Byrd and Mr. Daly, you're both from Maynard. If I pronounce that correctly.
Yes,
Do y'all know each other?
No.
Pretty small place. Ms. Ford, I certainly don't mean to ignore you. I haven't been able to talk to you very much so far. Is there anything about this case you would like to ask me any questions about?
Well, it's Mrs. Fuller.
Pardon me.
No, I don't have questions.
I noticed, Mr. Daly, that you have a relative that works in some branch of law enforcement.
Yes, sir. I have a brother who works for the Highway Patrol Department of Public Safety here in the state of Texas.
Is there anything you like him pretty good?
Oh, we get along just fine.
Pretty good
Yes,
fella?
sir. I think so.
Is there anything, I guess since he's been in law enforcement, you probably met a few more policemen or various peace officers of different kinds than probably before he was in that service. Is there anything in your dealings with these people that make you feel like you would give too much or too little credibility to their testimony?
Oh, no, sir. I like to think I can be fair.
You know, that's really all that we're interested from many of you, and ordinarily I would tell you a little bit more about myself, but that's really what we're asking you, to if you end up as a juror in this case, to try to be fair, and most of all, be reasonable. Some of the principles that you will be applying, I expect to be mentioned many times in this case, is the principle of reasonable doubt. You may see some quaint little representations of scales tipping one side or the other and indicating to you how heavy the state's evidence must be before we can prove this case. Well, I'm not going to insult your intelligence by using too many of these little tricks like that, because I think the longer you talk about it, the more obvious it becomes that what we're really going to ask you to do is use your common sense. Judge the credibility of this witness. Okay, Your Honor, I'll just take just a couple of seconds if it's okay. Use your common sense. When people take that witness stand, there's going to be some conflicts, I expect. You know, if we weren't in some disagreement, we wouldn't be asking you to come in here and settle this matter. Look at those people and say, you know, is that guy telling me the truth, really? Or is he the best person to be judging the facts or relating the facts to me? Might he be shading them a little? What does he have to gain by what he tells me? It's not a happy thing, but sometimes people do shade the truth a little bit when they're on one side of the controversy. And I would ask you to think, keep it in the back of your mind, who has something to gain or lose here, and who has most to gain or lose by telling me the truth or lying to me. And use your common sense. I'm sure every one of you can make a good juror in this case. And I thank you very much for your attention.
Mr. Johnson?
May it please the court, ladies and gentlemen of the jury. On behalf of Victor Alvarez and myself, I too want to join Mr. Oden in expressing our appreciation for the fact that you've come down here and volunteered to devote the next few days to what may prove to be a very important period in the life of Victor Alvarez. You may not long remember it, but the decision that you make, if you're selected to serve in the jury, is going to remain with Victor Alvarez for the rest of his life. It's an important decision there that you're going to be called upon to make. The legislature has seen fit to reimburse you for this experience at the rate of something like $10 a day. You're not going to earn enough to take a Caribbean cruise or buy yourself a new convertible. In addition to $10 a day, you probably will find that you have accumulated several parking tickets and undergo numerous other inconveniences that I wish you did not. But now, I think the county has worked out a little affair with the city that he will dismiss your parking tickets. I hope that, knowing that, you won't incur any special gratitude on your part, nor any tendency to vote in the manner he would have you do. I'd like to say at the outset that Mr. Oden mentioned that Victor Alvarez has selected to go to the jury in the event that he selected to go to the court in the event that he is found guilty by you, and that he has made an application for probation. Now, I want to say right off that he did not make this application because that he feels that he's guilty of this offense. On the contrary, he denies vigorously that he is. But the law requires that if probation is to be considered, then it must be submitted prior to the commencement of the trial. And if he waited until such time as he learned that you had, contrary to the evidence, convicted him, it would be too late for him then to make application. And that would result in his being forced to be sentenced to a minimum of 3 days in the Travis County Jail and a fine of a minimum of $50, as you probably all know. The penalty for driving while intoxicated is a jail sentence that ranges from 3 days in jail to 2 years, and also a penalty from $50 to $500. So anything in that range could have been imposed, but probation is authorized, and as a result, it must be submitted prior to the commencement of the trial. And I want that made perfectly clear because I don't want you feeling that it is in any way admission on his part that he is guilty of this offense. And I'm just going to ask you, Mr. Wilson, do you or would you consider that on his part as an admission of guilt?
No, not the way you explained it.
All right, how about you, Ms. Ford? And Mr. Bird?
No.
And how about you, Mr. Day?
No, sir.
All right. Now, Mr. Oden has mentioned that there is scientific evidence involved in this case. I'd like to also say that driving while intoxicated is the only offense in the Texas Penal Code that authorizes a conviction on the basis of opinion only. You can guess, in this instance, that a person is guilty, and the courts will affirm it. You can guess that he's guilty and form an opinion.
The courts will not affirm it on appeal, and there should not ever be a verdict rendered if someone has indulged in guesswork and make this. It's based entirely on credible evidence, or there wouldn't be a guilty verdict at the end of it.
Well, opinion evidence will sustain a conviction, and that's in many instances little more than guesswork. There's also scientific evidence, which we have available here, but scientific evidence nature that is taken, and I think the evidence will show, some hour after the individual has operated a motor vehicle on a public street in Travis County. And it's not against the law for him to be at the police station at 12:30 and register .12 or 0.12, and it has little or no bearing on what he might have tested had it been at the time he was operating a motor vehicle.
Judge, Your Honor, this in the nature of evidentiary argument right now. It has a great deal to do with it, as a matter of fact, but this is not the time for argument.
Sustained.
The fact is that the methods for ascertaining one's guilt or innocence are, in driving while intoxicated cases, very loose. And there is a method that would enable the state to prove precisely and establish totally by scientific evidence whether or not the defendant did in fact operate a motor vehicle at the time they operate a motor vehicle at a time when his physical and mental faculties were impaired. Now, the state is going to put a great deal of reliance on this one breath test, and I submit to you that that will not be enough. It's scientifically established that when you consume an alcoholic beverage, absorption into the stomach and the small intestine.
Your Honor, I'm sorry I have to keep interrupting like this, but we're getting an evidentiary argument right now, and nothing that I see in this line of testimony, in fact, from the defense counsel is going to put out, we can pick a fair and impartial jury.
Mr. Autry, could you pose it as some form of a question?
Some form of a question? All right, let me do that. Now, let's see. Who was no, it was the defendant that's the engineering student, okay. Are any of you knowledgeable about, well, let's say toxicology? Any of you knowledgeable about general science courses? Did you take any of that while you were in the undergraduate course, Mr. Burleson?
I took a biology course.
A biology course. And
Just basic.
did you study the time that it requires the system to absorb beverages such as alcoholic beverage?
I don't remember talking about how much time.
You don't
it
recall?
takes, no.
All right. Does it seem, well, I'll just abandon that for the moment and go on to something else. And let me ask you a few questions individually. For example, Mr. Dudley, you stated that you have a brother that's on the Texas Department of Public Safety.
Yes, sir, I told him.
And have you ridden with him on his rounds, any at all?
Oh, no, sir, I don't think it will take me long.
And so you've never been with him when he made an arrest such as the one on the way here?
No, sir, I'll leave that to him.
All right. Do you think that because of your association with him, you'd find it more likely to believe the testimony of a police officer than that of another average citizen?
Well, I can see how someone might think that I would, but as I told the other lawyer just a minute ago, I think I can be fair.
Well, fair to who? To the police officers who are going to be testifying in this case, to Victor Alvarez as well? Can you be equally as fair to Victor Alvarez as to the police officers who are testifying?
Yes, sir, I think that I can be fair to just about everybody.
Okay. So that if you were sitting where Victor Alvarez is today and looked up and saw someone, the brother of a police officer, sitting where you are, you're changing places with him. he has a brother who's a police officer. Would you, knowing what you know about yourself and applying the same knowledge to Victor Alvarez, would you want him serving as your tutor, on your tutor?
Well, sir, I can just answer this way. I think we all obviously have different backgrounds and so forth, and then you just never know what a person's going to think based on who he's kin to and anything like that. So I want somebody who's fair regardless of who his brother was, yes, sir.
All right. Now, a moment ago, you stated that you, for religious and moral reasons, do not drink.
That's correct.
Now, do you realize that it's not illegal to drink in Texas and operate a motor vehicle?
Yes, sir. I'm aware of that.
Are you in agreement with that law?
Oh, I suppose that if people want to drink, then they might as well be drinking when they're driving. I don't know, as I say, I'm just opposed to drinking in general, so.
Do you feel that one beer and you are, or one drink and you are effective?
Well, so the trouble with one beer is that it tends to lead to two beers, and two beers leads to three.
Well, do you know what the elimination rate of the body is, the burnout rate? If I drink one beer an hour, for example, how long would it take me to get intoxicated?
Oh, no, sir, my understanding is that varies quite a bit from one person to another.
Your understanding is that it varies?
Yes, sir.
But my question is, though, because of your own views concerning alcohol, would you want someone with your views regarding alcohol, if you could again place yourself in Victor Alvarez's chair, deciding whether or not you're guilty of operating a motor vehicle while under the influence of alcohol?
Well, sir, I see what you're getting at.
All right.
But on the other hand, I think, and I say again, I believe I can be fair, and I think I can distinguish what the law is from my own personal beliefs.
Well, do you have an idea of how many beers it might take to cause one to be intoxicated?
Oh, no, sir, I really don't know.
And if the evidence showed that there might have been 5 to 6 to 7, would that cause you to conclude he must be intoxicated?
Oh, no, sir, I've heard stories of people who can drink more than that.
Do you believe those stories?
Oh, I don't know if I believe or not, really. I just know that some people make those claims.
Do you keep alcohol in your home?
No, sir.
And if someone came to visit you, you would not offer them a beer?
No, I wouldn't be able to, no, sir.
Okay. How about you, Mr. Bird? You keep alcoholic beverages in your home?
Oh, yes.
And so you have no scruples then about one's use of alcohol so long as it's not.
So long as it's one.
Okay. Now, do you agree with the law that states it's not illegal to drink and drive?
Yeah. Sure.
Okay. I can have a few beers, and I can get in the car and go down for a loaf of bread or more beer for that matter, and it's not illegal.
I'm going to object to that statement, Your Honor. We're getting into legal issues that are not quite so clear as they're being represented here. You basically drive in Texas at your own risk if you choose to drink, and stating it as though you can have a few beers and definitely not be breaking the law is not a correct statement of the law.
Chuck, I believe that's correct. That's what you're saying.
All right. It only becomes illegal when you consume enough alcohol that your physical and mental faculties are impaired. We would agree
Yes,
with
Your
that.
Honor, I'm going to have to, I hate to keep interrupting that, but that's not a correct statement. It's either your physical or your mental, not your physical and your mental. Many times people react to alcohol differently. It could be one or the other and still be a violation
Ladies
of
and
the law.
gentlemen, the court will charge those members who sit on the jury that one may not drive if one is so intoxicated that he has lost his mental or physical faculty by virtue of the consumption of intoxicating beverages. That's the law you will receive from the court. Drug code.
Thank you. How about you, Mrs. Fuller? the same questions posed to Mr. Byrd. You have not, you have indicated that you drink moderately. Okay. You keep alcoholic beverages in your home. And agree that it's not illegal to drink and drive.
Under some circumstances, I guess it would be illegal.
Well, do you agree with the court's definition of intoxication? That,
Sure.
beg your pardon?
That, I mean,
That
physical or mental.
it's illegal to operate a motor vehicle on a public road when your physical or mental faculties have been impaired by virtue of use of alcoholic beverage.
Your Honor, I hate to do this, but we're leaving out a critical phrase in our legal definition and we keep using it, that is the normal use of your physical or your mental faculties. And that slight impairment can...
Mr. Autry said impaired, but Mr. Autry, of
I
course, it
didn't
is
see.
a normal use.
Right. Okay. So you agree with that definition?
Yes.
Okay. And how about you, Mr. Brooks? You're not also a lemon drinker.
Correct.
Do you serve it to guests?
No, I don't have it.
So you don't keep it in your home either?
No, sir.
And asking you the same questions that I put to Mr. Davis. What do you feel about one drinking and driving?
Well, I guess my gut reaction is that it's not a good idea. I'm kind of used to the old saying
All
that
right.
those two things don't mix. I've seen people that, I've driven with people that have had a beer or two, and I wasn't particularly nervous about taking a ride with them. It's still my gut reaction, it's not a good practice.
Are you of the view that if it takes 20 beers to become totally intoxicated, you're 1/20 drunk when you have one?
No, sir, I wouldn't say that. The defendant, I think the evidence will show that he is a Nicaraguan student, and he had attended a Nicaraguan party. That the evidence, he will be testifying. Now, the decision as to whether or not he will testify is not really his, it's mine. But in this instance, he would. The law provides that should he not, or should I have decided that he is not to testify, you would not be permitted to hold that against him or as any indication that he is at all guilty. But the fact is, he will testify, and he will attempt to tell you precisely what he recalls of this whole episode. And he will relate to you, as will witnesses that were at the party he attended. And there will be approximately 3 of those, in addition to the guest or the roommate that was with him at the time of his arrest. He will come forward and relate to you all that he recalls of this and the circumstances as it is remembered by him. Now, one of the things that I want to ask you about, and that is been alluded to by Mr. Oden, there may very well be differences of testimony here. Now, you're going to be the sole judges of the credibility of the witnesses and the weight to be given to the testimony of each. Now, police officers, even UT police officers, are constantly making arrests. Now, that's just a fact of life. There's a possibility that I want you to keep in mind when you're doing this, that the distinction between various arrests can blur, and facts that are actually associated with one arrest, it is possible to confuse with facts concerning another arrest. I mean, these are possibilities.
And these are factors that I would want to ask you on Victor's part to listen to very carefully. Also, this has never happened to Victor Alvarez before. This is a matter that stands out in his mind with a great deal of clarity. And these are factors that I want you to remember when you're listening to the officer's testimony and the testimony of Victor Alvarez. Now, Mr. Oden says, who has the better reason for being truthful? Who has more to lose, I think is the way he put it. Well, we all stand to lose. The state, the community, everyone, if we convict an innocent individual. And just as much to lose as Victor Alvarez does if he is convicted. Because we all lose by an unjust verdict, an unjust decision. The system isn't supposed to be or operate in that way. Mr. Campbell.
You have 10 minutes.
Okay. Now, I would like to get back to this breath test. I'm not sure that I can get this in over the objections that have been posed, but I'm going to try again. It stands to reason, I think, that it requires some time for an alcoholic beverage to be absorbed. It stands to reason that some time is required. It stands to reason, and I think the evidence is going to show in this case that at the time Victor was arrested, he had a can of Budweiser that he was in the process of drinking. Okay. Now, consider, if you will, the fact that that was in the process of being consumed at the time that he was stopped. Okay. Would that have affected his driving at that particular moment? Was that absorbed into his system and affecting his mental or physical faculties, or his normal use of his mental or physical faculties? Or would that have shown up possibly an hour later? These are things that are to be considered by you. And the rate of absorption of alcohol by the system, don't you think that's going to?
Your Honor, I'm going to have to object at this point. We are continuing in this vein testimony on the part of the defense counsel. We have a whole trial ahead of us to determine whether or not there's credible evidence on how this breath test was administered, whether or not you can trust that evidence. Right now, we need to know if we can get fair and impartial jurors, and I don't think we're at the stage where we're supposed to be arguing the case.
I don't believe Mr. Autry, he has a stated rate of absorption. I believe Mr. Autry, you may inquire whether the jury will be able to consider the lapse of time between the alleged consumption and the giving of the test.
Well, don't you think that the absorption rate of alcohol into the system is going to require some time, and that the rate of absorption, don't you think that's going to be sort of contingent upon and dependent upon the number of drinks consumed within a given period of time? Well, these are all factors that are going to have a great deal of influence on the validity of the test that the state is going to place so much confidence in, and based upon which they're going to ask for a guilty verdict. But the integrity of that test now is for you to decide, and you alone. And these are questions that are applicable in that instance. And I want you to be aware of it if you're chosen to serve on the jury. Well, I know that you're probably really about as exhausted of hearing this as I am. So I'm going to cut it short now and give you back just a few minutes of your time. Okay? Thank you very much.
Real hard to do a good voir dire in 30 minutes. There were major portions, I think, in a case like this that you should always get to that if I touched them, I just bumped them in one on them. Ordinarily, especially with my approach, if you're working with an accent like this, you've got to get over that hurdle to begin with. And I think usually on voir dire, I found it when you start getting into personal things, I usually try to start off with kind of telling you something about myself, where you say if he's willing to divulge some of these skeletons in his closet, or just kind of personalize yourself a little bit. Then
Testifying.
well, or just what a hell of a guy you really are. Yeah, that's a good start, anyway. And some of the more important things that ulterior motives that the state has, but they can come in sheep's clothing and say, you know, this guy, he can testify or he cannot testify. It's his decision. And y'all will never hold it against him. But, you know, just talk on that long enough, saying, hey, they're not supposed to consider it, and talk about it long enough until they have to consider it. And I really expected, I even brought a case, I expected an objection, because I only found out in the last day or two. I've never used the thing about saying bifurcated system, and when you get to that stage, it's a different type proceeding, therefore you introduce a different type of evidence, and it's only then that we can rightfully use sympathy, and it's only then that we can rightfully consider his reputation and his prior criminal record, if he has one. The prior criminal record, as long as you don't personalize it to that defendant, I understand that's real borderline, but that you may be able to do it. I think in voir dire, it really depends on the type case as far as the approach you should have. In my limited experiences with DWIs with this type of case, I guess any case where it's important that you have two things from the state's point of view that you really have to deal with to ask to enforce the law and extract promises. You know, even if people don't agree, even if you get a kind of borderline ringer on the jury, most people, once they promise they'll do something, by God, they'll usually stick to it pretty close. At least you've got a much better chance. And if you can extract a promise that they'll follow the law, and DWI or anything that requires two things, I say in DWI, that legal definition of intoxication is the best thing the state's got going for it. And in any kind of case where you're dealing with a legal definition, which may be watershed one way or another, if you can extract that promise and really hammer it home and make them feel like, I don't really have a place on here unless I'll do that, and I promised I will. The other thing is on the presumption of breath test, which I really didn't get into at all. It's so important in a case like this, that explaining what the presumption means, because from the state's point of view, I think that's mishandled a lot of times. And that is, you hang your hat on that presumption, hammer it home so long, and they feel like, by God, they sink or swim on the presumption. When in fact, the presumption for the state should cut both ways, because all it's supposed to do, if you can sell it properly, is convince them, boy, have we got the hammer, we got this presumption here in breath test, scientific evidence and everything. But even if you get tacked on that, and the bottom falls out of that, then you just fall back to the other kind of evidence, and we no longer have the presumption, but you still have to judge credibility and still who is most believable. And even if you think it's a little bit more below 0.10, then you can still be intoxicated and hammer that home. So I think if you start out early and don't hang your hat, then if you get torpedoed on the presumption, you've at least got a fighting chance at that point. I didn't touch on that at all. Usually, also, I think it's a good idea to kind of formalize the proceedings and the gravity of it and everything by reading the complaint, reading the information, so that you get a it looks like someone has mulled this thing over, and surely we wouldn't leave here unless this good old boy up front here has decided this is a grave enough offense that we'll do all this paperwork on you and get him up here. I got too long-winded and didn't have enough time to do the individual questions. I thought Tom touched on a couple of things that was silly for me not to have. That's the Nicaraguan issue, because I could see there's a real hotbed there potential where you got UT cops and at least one UT student, maybe several, a couple of religious fanatics, and I see a lot of potential there, and I didn't even see that either. To me, I guess the most important thing on Voir, other than the really getting to the ringers, and you're usually, unless you screw it up pretty bad, you can usually get those, the people who have law enforcement brothers and sisters or strong religious convictions against the crime or even against the defendant. You can usually spot those unless you really foul it up, but then you're going to get some people on there that's possibility of persuading in one way or another, and to me, Voir is your big chance to make them like you. And because if you don't do it then, you're probably not going to do it. If you can't draw them out, and like Bill said, get them to talk to you, get them enough to learn enough about their personality, whether or not they're even susceptible to persuasion. That'll be your only chance if you don't do it then.
I'll get in there.
Well, contrary to what an awful lot of the lawyers think, this period here, in my view, is solely to establish a rapport between you and the juror. And I think that rapport is the most important thing that the lawyer can do. If he can get that rapport, then I think he is well on his way to making a good showing in the case. Now, it's hard to do. It's very hard to do. We talk too much and listen too little, I'm afraid. But if we can get you talking, then we can judge, maybe not well, but we can judge what you likely will do, confronted with the evidence we know you're going to hear. But that rapport is so important that it will cause us to do everything we can to keep the jurors that we have that rapport with. Even cheating sometimes. I recall once where there were 3 jurors that I wanted on the jury very, very badly. And the prosecutor, I knew, was going to strike them. So I made a little strike list and let it slip off my desk down toward the prosecutor's table. And he happened to look at it and cheated and didn't strike those 3. As a result, I kept the 3 I wanted on there very much. But it was the matter of rapport that I've established with that with the jury. And I can't stress that enough. That's it.
I will make one comment about a ruling that I made so you're not misled. I think
incident, whatever the facts may be on that, did that or did that not contribute? We just don't know enough about that to say that it was not something that contributed to his later injuries. So these are the kinds of things, when you look at the pain and suffering now and in the future, he may well have pain and suffering. He has this congenital back problem. He had it early on. Dr. Yeager noticed that. Dr. Wolf noticed that. That's a consistent condition. But that, ladies and gentlemen, is a congenital condition that has nothing to do with the accident.